Why doesn't the Philippines bring the case unilaterally without Malaysia's participation, just as it did against China regarding the 9 dash lines in the South China Sea? This was brought up by one of the commenters, and this will be the topic of this video. However, before I begin, I would like to extend a huge thank you to all of you who have been actively commenting on my recent videos about the Sabah dispute. While this may be a smaller channel, the level of engagement and the depth of knowledge within this community are truly remarkable. Honestly, I've learned a great deal from your insights and contributions. You, the viewers and commenters, have significantly expanded my understanding, filling in crucial gaps in this complex situation involving Malaysia, the Philippines, Sabah, the Sultanate of Sulu, and the Philippine government. Your active participation is invaluable, and I genuinely appreciate it. And if you're new to this channel, we welcome your engagement on this complex topic by watching my videos, which break down the different aspects of the ongoing Sabah dispute. Now, let's start with two individual commenters who highlighted that the recent arbitration award concerning the Sulu heirs was annulled and declared invalid by the Paris Court of Appeal, a decision later confirmed by the same court. And the critical reason wasn't a minor technicality, but something fundamental: the lack of an arbitration agreement. As both the commenters put it, no such agreement exists, which is why the arbitration award was annulled and deemed invalid. This is absolutely key. In international arbitration, consent is king. You cannot be forced into arbitration unless you've specifically agreed to it in advance. The Paris Court essentially said there was no valid contract for this arbitration to even begin. This isn't just a setback, it's a fundamental invalidation of the entire arbitration process for the Sulu heirs' claim from Malaysia's perspective. The arbitration's failure raises a critical question. Why does the Philippines' strategy for the Sabah sovereignty claim differ from its approach to the South China Sea dispute, specifically concerning the ability to pursue a unilateral case before the International Court of Justice? It's a powerful question because, on the surface, it seems like the logical next step in international law. But as with all things in international relations, the answer is far from simple. It delves deep into the nuances of international law, complex diplomatic relations, and the cold calculations of geopolitical strategies. I'm going to walk through some of my thoughts and theories about why a state might or might not take a high-stakes case like this to the ICJ. Remember, these are my perspectives, and I encourage you to form your own conclusions. Now, firstly, let's discuss jurisdictional hurdles. Even for a unilateral application, the ICJ's jurisdiction isn't a given. It fundamentally relies on the consent of states. In the South China Sea case, the Philippines' claim against China was brought under the UN Convention on the Law of the Sea, a treaty that both countries had signed and which explicitly provides for compulsory arbitration in certain maritime disputes. For a territorial sovereignty dispute like Sabah, the basis for the ICJ's jurisdiction might be far less clear-cut or require a specific pre-existing agreement from both Malaysia and the Philippines to submit such disputes to the court. It's not simply a matter of walking in and filing a claim. Secondly, we have the immense diplomatic and geopolitical cost. Malaysia and the Philippines are not adversaries in the same way as China and the Philippines have been perceived in the South China Sea. They are close neighbors, fellow members of ASEAN, the Association of Southeast Asian Nations, and significant economic partners. Launching a unilateral ICG case against a close ally could severely strain these vital diplomatic ties, potentially disrupting a regional cooperation and resulting in substantial financial repercussions. Is a legal win, however righteous, worth alienating a crucial partner in the region? Huh? Third, there is the critical assessment of the strength of legal arguments and evidence. States don't go to the ICJ lightly. They invest enormous resources and political capital. They rigorously assess their chances of success. As our commenter also pointed out, the ICJ previously rejected the Philippines' application to intervene in the Sipadan and Ligitan Islands dispute between Malaysia and Indonesia. The court stated that the Philippines couldn't make a claim based purely on historical grounds in that context. This prior decision might certainly influence Manila's perceived likelihood of success with a historically rooted claim over Sabah, suggesting a higher bar or different type of evidence might be needed than what they currently possess or are willing to present. Fourthly, and perhaps most critically, we must consider the differing levels of immediate threat and strategic priority. While Sabah claim is a significant historical sovereignty issue, the situation in the South China Sea involving China possess a far more immediate and pressing threat to the Philippines' national interests, security, and economic well-being. China's actions, such as the militarization of features, harassment of Philippine vessels, and encroachment on vital fishing grounds and potential energy reserves have direct, ongoing, and tangible impacts. Pursuing a binding international arbitration on UNCLOS matters was seen as a crucial step to address these active challenges and seek clarity on maritime rights, which are vital for daily life and national security. The Sabah claim, while important, doesn't carry the same acute sense of urgency or ongoing hostile interactions that demand an immediate international legal intervention in the same way. And finally, let's consider the issue of enforcement and compliance. As the commenter shrewdly noted, the ICJ, while the highest court of international law, has no direct enforcement mechanism for its rulings. Its judgments rely heavily on the parties' willingness to comply. We saw this with China's non-compliance in the South China Sea arbitration. If the Philippines were to win a unilateral case against Malaysia and Malaysia chose not to comply, however morally wrong that might be, what would be gained for the immense diplomatic and financial cost? A victory that isn't implemented can feel like a pyrrhic one, meaning it comes at such a great cost or has so little practical effect that it's almost as bad as a defeat. So, there you have it. My breakdown of why the Philippines' approach to the Sabah claim might differ so much from its South China Sea strategy. As I've said, these are my theories based on legal viability, diplomatic considerations, and strength of arguments, enforcement challenges, and critically, the immediate threats faced. Now, I'd love to hear what you think. Do you agree with my points or do you have different theories? What conclusions can you draw that might shed even more light on this complex issue? Let me know in the comments below. And if you find this video insightful, please hit that like button and subscribe for more discussions on international law and geopolitics. And don't forget to ring that notification bell. Thanks for watching, and I'll see you in the next one.